So in today's session, y'all, what we're going to be going over are what I feel is one of the biggest challenges when it comes to wholesaling real estate, especially in dealing with properties that are dilapidated. All right. Now, properties typically go through stages of dilapidation. It doesn't necessarily mean that they're going to get worse, like worse and worse in condition. What I'm saying is that there's going to come a time in these properties where, there could be something that's underlying. It could be a child support lien. It could be a mechanic's lien. It could be a contractor lien, a landlord lien. All of these different types of liens are essentially debilitating situational things, and each one is different that puts the property into a level of distress because the homeowner, for whatever reason, did not settle a debt. And that could just linger, that could happen. Now, these legal claims can complicate the crap out of these deals if they're not handled correctly. And so, in today's session, what we're going to be going over is the process of identifying, understanding, and resolving these issues, both with and without an attorney, because this can be done in so many different ways. Okay. But for us to do this, we have to first understand what a lien is and what a judgment is. So a lien typically arises from some form of like unpaid debt. This could be taxes, this could be contractors. How many of you guys live in an HOA? I live in an HOA. I can't stand it, to be honest. HOA has put a lien against my property before just because I had my boat in the middle of the road. Not in the road, but I had it parked out there for 2 weeks one time, and I didn't put it in my driveway because I like parking my truck there. So I had my boat on the road, and the HOA came and they wrote me a ticket for it, like a violation of the HOA terms. And then next thing you know, I didn't get that in the mail because I'm just being real. I'm 34. Okay, so like if you want to send me details on something, you don't just tell me about you don't just put it in my mailbox. You actually email it to me. You know what I'm saying? Like I don't know if I'm the only one. I don't check my mail. I don't know about you guys, but I look at my email. That's my mail. And so like they ended up putting a lien against my property for that. And so I had to settle that lien. And it was about like $800 just for having my boat parked outside the front for 2 weeks. And I wasn't moving it anytime soon. So that's it, right? Now, typically, guys, what a lien is, it's a security to the debtor against the property, and it must be paid before the property is sold. And so there are positions of liens. And I don't know if y'all understand how these things work, but I'm just kind of bring it, I'm gonna bust out like a quick little whiteboard type thing so we can go over it together. And I can show you what it is that I'm talking about. So I'm gonna hit new, boom, and don't show again. We can go whiteboard classic. So when you get a property, right, we'll say that this is the property here, right? And 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 the way this works is
Bookstore.
if for whatever reason, hold on, you can mute yourself, boss. If for whatever reason you have like let me give you an example. Let's say I decide to pull out a mortgage on this property, right? So then let's just do that. We'll call this the mortgage here. Boom. That's the mortgage. And then what we're going to do is we're going to connect this to that. We put out a mortgage against the house. Now this here is what you would call lien 1, or first position lien is another word for it. Okay? Everybody can see that? And so this is the original debt that gets accumulated for any property. So let's say that my guy Cedric here owned a house, right? And he wanted my help. He needed to get like a $30,000 loan because he wanted to fix it up. He bought it outright cash. And so I say, you know what, Cedric, it sounds like a great deal. And so I lend him the 30 grand. And then I lend him the 30 grand. We sign a document, which he gives me first position lien against that property. First position lien means if for whatever reason Cedric does not settle this debt, I can take him to court for it. And I can also foreclose on this property for non-payment of that debt, of that lien. And so this gives me first position. Now, let's say I lent Cedric the 30 grand and we decided on a 15-year term. So he's got 15 years to pay me back. Okay. And so during that time frame, let's say something else happened and he wanted to pull out a home equity line of credit for the property. And so this type of loan is called a HELOC. It's still a lien, right? And so in essence, what happens is he pulls out a second loan against this property. And so this right here, my friend, this second loan to this property is what you would call lien two, or second position lien. Y'all know what I'm saying. I didn't spell it right, but whatever. So second position lien is similar to first position. The only thing is that second does not have priority over first position. That's how this works. And so for whatever reason, let's say that Cedric stops paying on lien 2 and the bank decides to foreclose on him, they can't wipe me out and it would fall back on me. So if he were to get foreclosed on for being in second position lien with this other bank, the bank would take the property from him, but I would still have first position ownership. They would still have to pay me out my 30K for them to essentially move from here to here. You see what I'm doing? So there's positions of liens. The best position of lien that you could ever be in is first position. All right. Second position is decently okay. It's just as good as first position, but it's not entirely first position. It still gives you legal authority. You see, what a lot of people will do when they buy property subject to, who here is familiar with what subject to is? Say I, drop a one in the comments if that's you. So sub two is the act of taking over the payments on a property, right? And typically you're looking at some type of debt, some type of issue, and then you'll go into there. You'll decide that you want to take over the mortgage. When you take over the mortgage, what happens? Right now you're entitled to pay in that mortgage. Well, let's say I don't want to rent it and I want to sell it. I want to sell it, but I still want to hold my position. I will utilize a strategy called a wraparound, where I essentially sell the property owner finance on a second position loan. A second position loan. This is called a subject to with an owner finance wraparound. Subject to owner finance wraparound. Okay. And what I'm doing is I'm selling the property. The original mortgage, the first lien position from the bank is going to stay in place, but I'm going to sell the property on a 15-year note at a 9.99% interest rate, right? And I'm going to collect passive income. The difference between loan 2 and loan 1 is what I would make every single month. Essentially, when you sell a property this way, you become the bank. So you becoming the bank gives you that legal authority to foreclose on that person that buys your property, okay? And take that property back. Now, you will never be able to wipe out lien one unless you decided to go in and pay it out in full. But what you're doing here is you're essentially utilizing debt two to pay for debt one. The mortgage payment that you're paying on a property like this that's worth 200 grand, probably close to 12 to $1,300 a month. More than likely, the sub two loan has been in place before the interest rates rose. So you might have all of this monthly payment to pay, but when you sell it on a 15-year note, you're essentially putting a second lien around this property. It's called a wraparound around the first lien, right? Because you have the first lien, which is your $1,200 monthly payment, which includes PITI. That stands for principal, interest, taxes, and insurance. So everything inclusive, $1,200 a month. When you sell it on a wrap, their payment's going to be like $2,200 a month. And for the next 15 years, which is 180 months, you're going to be collecting $1,000 in passive income for this property, whether or not they fix it, whether or not the property starts to be more dilapidated. It doesn't matter because you no longer own it. They own it. So you give up your equity by doing this. Now, a lot of people would look at it as the passive because the passive is where you're at. Now, what's cool about it is when you have debt like this, you can sell off shares. Like if you wanted to, I could sell off like let's say 10 years of my debt that I have that I created with this guy that's paying me back. It's called selling a note. And I can sell my note to Candace. You know, let's say that Candace wanted to buy 10 years of the property and passive income that I'm going to collect, right? So she comes into an agreement with me, and Candace says, you know what? I'll give you $100,000 for 10 years worth of passive income from this property. And so I'll give it to her at a discount. It'd be 70 grand up front, and she's gonna make $30,000 in passive income by me selling off my debt to Candace. So, like, again, that's selling a note. The note is what you get when you sell a property like this. And let me give you an example. Whenever you buy a house, there's typically three instruments. You get a deed of trust. A deed of trust is what secures your loan with someone else, which is a lien, okay? And then you get a general warranty deed, which is title. The title will protect me. Again, like Candace would get title to the property. I'd give her the deed. but the deed of trust would stay in place in my name. So I'd control the debt. And then you get a note. And a note is your payment schedule. So that's what your PITI is. It's all located inside of the note. You see, in Texas, we're a non disclosure state. So you'll never be able to know what somebody else is getting for their property on a monthly basis. You might understand how much money they borrowed to buy it, but even then, they could have borrowed that amount of money, but they could have gotten the property significantly lower, and they could have just been cashing out all of their equity. This is what it's like when you're doing business in an area that is a non-disclosure state. All right. And so, does everybody understand what first position lien, second position lien, third position lien, fourth position lien? Guys, the lien positions never change. If the more debt that comes onto a property, it's there in tiers. The strongest position of lien is which one? So I want to make sure everybody is listening. What's the strongest position of lien? There you go. Cedric, you had a quick question?
That was a lot of information right there, right? So I'm gonna have to go back and watch this at least like 2 more times.
You're
So,
good.
so real quick, let's say we take the. I just want to ask this question. Let's say we take the first, second, third, fourth loan. Now, let's say I got a house. I'm falling behind on a house, and somebody wants to come in and take my house over. And what is the term? I was because a friend of mine just asked me this. I said I'm gonna ask this when I get in the group. They come over and they want to take over my loan.
Correct. That's called subject to.
Okay, so that's what it was. It's called the subject to owner wraparound.
So a subject to is different. A wraparound is different. Those are two different strategies.
Okay.
A sub
Okay.
two is an entrance strategy. It's how you get into a property without using any of your own money and any of your own credit.
Okay.
Essentially, you're looking for properties where somebody is defaulting on their loan. And your agreement is to take over their loan in their place in exchange for the title of the property. The deed of trust would stay in your name, Cedric. So if I went and took over your property that you live in right now, you would keep the deed of trust. I would
Mm-hmm.
get the general warranty deed, which is the title. You would
Mm-hmm.
give me the title. Now, for me to handle that loan in your place would require for me to have power of attorney over you. So you and I would sign a purchase agreement, some closing disclosures, as well as a power of attorney. It's not a normal power of attorney. It's not a power of attorney over your whole life. It's what you call a statutory durable power of attorney, which gives me only authority legally over you that in regards to anything to that property. So
So,
that
but you
power of
would,
attorney would
but
give
you,
me the authority to pay that mortgage in your place, to refinance that property in your place, to sell that property in your place even. That's what the POA would do for me.
so how will we do the communication with the bank to get it out of foreclosure though? Like, because
We would work with you. So if I were buying your property and you were going into foreclosure, I would put the property under contract, tell you that I'm going to buy that house. I'm going to take over your payments on the house. We would have to contact the bank with you and put that loan back current so that you don't lose the property.
okay.
But we
All right.
have to be contractually bound first, man, because I'm not going to go and pay your debt and then you sleaze me and decide to not move forward with the sale.
All
So
right. So look,
typically, everything happens at once at
so then
closing.
then one more question. I'm gonna cut you off. So then one more question. I could also stay in the house and then also pay you rent instead of paying the bank, or I could just move out and you can find another tenant to move in. That's an option too, right?
Correct. I
All right.
wouldn't trust you as my tenant because you're already defaulting on your loan, and I don't give ownership and tenants like bad credit history. To me,
Okay.
you were already losing the property. It's more advantageous to me to get you out of that house. If I can get you out of that house, then I'll put a tenant inside of it, or I'll
Okay.
sell it owner finance on a wraparound mortgage, and I'll collect the difference. That's an that right there is a subject to entrance wraparound exit. So what I'm doing is I'm just getting myself into your shoes to pay your mortgage for you. That's it. I made your loan current. Now I want to get my money back. So when I sell it owner finance, I'm gonna sell it on a 15 year. You're gonna put 30, 40K down, and then you're gonna be paying way more because my interest rate's going to be higher than what the mortgage rate is that I'm paying for your mortgage. And I collect the difference. So if your monthly payment is 2,200 and my monthly payment with you is 1,200, then I'm collecting $1,000 a month for the next 180 months. Essentially, I made $180,000 plus 30 grand down for your property, not even including interest.
All right. And that's called a subject to entrance wraparound.
Sub two entrance strategy. That's all it is. It's just a way
Okay.
to get into a deal. Wraparound is the exit strategy. That is
Okay.
what you plan on doing. Now, the exit strategy can be anything, bro. I can buy your house sub two and I can flip it. I could buy your house sub two and then I can rent it. I could buy your house sub two and I can do a lease option. I can buy your house sub two and I can do a wraparound.
Okay.
It's just an exit strategy, and there are plenty of them. I've bought in sub twos in so many different types of ways. This is just one of them. Now, I'll probably end up doing a whole segment on subject two for you, Cedric. So maybe I'll throw that into the cheat code later. I've done about 100 of them, and I own 44 of them. So I can tell you from experience, it's a great way to do business. There are some things that you should be aware of. Okay, there's this thing called a due on sale clause, and essentially, if I were to take over your mortgage, the bank could see that if they were to do the research and call the note due. If they do, my friend, you and I are screwed unless I come up with the money to pay off your loan in full. They'll foreclose on your property and take it in full because they saw that a deed was transferred. It says this in every deed of trust that if title is transferred for whatever reason, the bank has the legal authority to call the note due. And that means that they can ask for the full amount up front. And if you don't pay that, you get foreclosed on. And so I love doing these things. There's a lot of cool ways to do it. Like my friend Isaiah was talking about, I do it in a different way. I put all my subject to properties into a trust and I name the trust the address of the home. And in case the bank were to tell me anything about it, right? If the bank were to be like, why'd you transfer title into a trust? I'll say that it was for privacy reasons and I'm protecting my family. So there's that part. Okay. So there's a lot of ways that you can protect yourself from a due on sale clause, but there's no definite way of doing it. They could still, even if you put the property into a trust, call the note due. It's almost impossible to bypass a due on sale clause. The only thing that you can pray for is that the bank never cares that you're on time with all of your monthly payments and that they never check that the deed of records have changed. If they do, just make sure that that property, when you buy it sub two, that you put it into a trust, you name this trust the address of the house. A lot of times they'll see that and it won't raise a red flag because it's just an employee doing a quick little, review on every property that has a loan. Now, again, this doesn't happen all the time, but I've seen it happen and it's happened to me twice. Out of 100 sub twos, I have a 98% success rate. Those two were nightmares. The first one, I didn't have the money. I didn't want to source the money. I didn't know where to put the money. And we ended up losing the house. My seller got foreclosed on. I did everything I could to try to help her, but the house got foreclosed on. The second one, when the bank called it due, I had to come to the table with 70 grand and pay it off in full, which I still own that house today. That's one of my rental properties. Now, I'll probably do a deep dive on sub two so that all you guys can kind of know how to do it. I teach sub two on a lot of different levels, not just the way that Pace teaches it, which is a good friend of mine. Pace teaches it the traditional way. I can show you guys how to buy properties subject to liens, subject to foreclosures, subject to death and probate. They call them death twos. There are a lot of things that I've learned in the market that are subject twos. You can buy a property subject to the taxes. So have you ever had a house where the tax bill was killing it, right? And there's like 80 grand in taxes owed on the house? You can buy those sub two as well. The problem is you won't get title insurance. So you would be taking an abstract of title. I know that these are crazy terms. You guys are going to learn them as we progress through this program. But for the sake of this video, I'm going to jump back into the original topic, which we're talking about removing liens and judgments. Just know that this cheat code, this rabbit hole that you guys are in, is what we're going to be going down 4 times out of the month. Okay. So again, this is going to be a rabbit hole of information. Things that I've learned from attorneys, things that I learned from experience, and real estate deals that I've taken on throughout the years. And so going back to the topic here at hand, right? So a lien is just debt that is secured against a property that has to be paid in full before the property can be sold. All right. And they're legal claims. Sometimes they're just security for debt. A judgment is different. A judgment is court orders that are attached to the debtor's property as collateral for unpaid debt. So a judgment is like, let's say for whatever reason, my dude Jonah here sues Q. He says, Q, you're full of crap, my guy. I'm sorry I invested in your program. I want all of my $97 and some change back. And so I'm like, oh, snap, I'm getting sued, right? And I just, you know what? I toss it under the table. I say, you know what, Jonah? I gave you everything I could. Sorry, man. Sorry you weren't happy, right? And Jonah's like, all right, well, I'm taking this to court. And he takes it to court and I ignore it. I ignore it because to me, I just don't think that it was that important. But now I get a default judgment against me and Jonah actually wins in court because I didn't show up. And so guess what? That default judgment will have to be settled at some point in time. The judgments are placed against the debtor and the debtor's assets. And so a lot of people will pay for a service, they'll pay for something, and they don't feel that they're getting what it was that they paid for. It could be a $15,000, $25,000, $100,000, $200,000 purchase. That puts you in legal standpoint if there is a breach of contract to sue that individual and everything that they own. So when you sue that person, essentially what you're fighting for is a default judgment. The court ends up paying them out and then they go after you for the debt. That's not always the case, But if you ever heard the term settlement, a lot of times the individual will just say, rather than a default judgment, I will just pay you 3 or 4 grand, get out of my hair, and we're done. And so what happens though is that a lot of times people don't take that seriously. And so it falls on the debtor, that debt, that freaking that default judgment. All right. Now I want to go over a couple of common different types of liens and a few common different types of judgments. Essentially, guys, a judgment is a lien and a lien is a debt. They're the same. So there's tax liens. These are imposed by the government for unpaid property taxes. Not property taxes as well, but also business taxes. So if you're a business owner and you're watching this and you haven't paid your taxes, the government can place a tax lien. It's called a federal tax lien against your property. And that means that you have to pay this debt in full prior to you selling this house or transferring ownership. Mechanics liens. These are filed by contractors who provided a service for unpaid work. So if I were to own a contractor company, right, and I said, you know what, I'm going to go ahead and I'm going to do Manny's house, and I go and I do Manny's house, and then for whatever reason, Manny doesn't pay me, then I can put a lien against his property. All right. Does everybody understand that? Mechanics liens. Now, judgment is different. Judgment lien is normally the result of some form of lawsuit or court judgment where the individual who was being sued did not perform. And then an HOA lien. An HOA lien is typically placed on like through a homeowners association for unpaid dues, which is what I had on my house. Can't stand HOA, man. Like, truthfully, if I would have known that this property was in an HOA, I probably wouldn't have bought it. I swear I'm going to buy a ranch somewhere and live there off grid, and I'm only going to see you guys through a camera. So, why does removing a lien matter, right? It clears title. That's number one. Increases the property's value, right? Because essentially you won't have any debt, and ensures a smooth close. So, you don't have to worry about the property not closing. But there's a lot of ways that you can identify whether or not there is a lien or a judgment against the property. You can do it on your own. You can do this on your own by going through properties and looking at the tax assessor collector's office or the county recorders, which is called the county clerk system. And you can look up the address for any house to see if there are any existing liens or judgments. You can also have your title company conduct what's called a preliminary title search. So I love doing this because it costs sometimes $20 to do it, but you pay the title company, they send it off to the examiners. The examiners will take a look at it, and they're going to go from the birth of the property to the land being settled all the way to the house being secured and owned by you. It's called a chain of title. Now, this chain of title leads all the way back to the dawn of time at which the address and the plot of land was created, goes all the way back to the early 1700s, 1800s. It's crazy. That's how far back it goes, all the way to now. Okay. And in that time frame, what they're going to do is they're going to cross-examine specific information to ensure that there are no red flags, i.e., unpaid taxes, lawsuits, contractor disputes. They look for everything. All right. Now, there's a lot of ways that you can go about removing these liens and removing these judgments. And so, like, one of the things that I've learned, and I'm going to show you guys like a real example here. Here, I'm going to go over this real fast. Removing judgments and liens is one of the hardest things, but I kind of want to go over this. This is worthy for all of you guys to write down. Okay. So there's stature, they're called statute, the stature of limitation on liens. And we're going to go over all this together. Okay. So write this part down. Federal tax liens can hold power for up to 10 years from the date of the assessment unless the IRS removes the lien. So if you have a federal tax lien, which is from the IRS, putting a lien against your property, that has a 10-year statute of limitation. State tax liens vary. These are properties that have unpaid property taxes against houses. This varies from state to state, but this is worth writing down. The statute of limitation is between 7 to 20 years. You're going to have to check with your county, call a local attorney, make it seem like you have a lien on your house, and get some free advice. Mechanics liens can last usually between 6 months and 2 years, and it depends on your state. Okay. And so if the lien holder does not file a lawsuit to enforce the lien within this statutory period, the lien becomes unenforceable, which means that you can literally remove it from your house. You can do so by contacting the debtor and asking for a settlement. There's a lot of title companies that will just bar the lien. Barring is a statement in the title world. Okay. And it's essentially where the title company does not see the lien as a threat. So they are willing to make it an exemption to the title policy so that they can issue you a title. You just have to prove that the debt no longer exists and that there's no way that that debt could come back. Okay. And a lot of times the title company will have to go back with the management, will have to go back with the examiners to kind of give you an idea of what that looks like. HOA liens, this is another time frame, write it down, typically lasts between 3 to 10 years. Again, many states allow the renewal of HOA liens with literally little action. I'm talking like they don't even have to go to court, they can just renew it. Now, voluntary liens governed by the loan agreement and state foreclosure laws, aka like mortgages, those last until the property is repaid in full or the house gets foreclosed on and the debt is wiped out. Okay. Now, guys, there are so many ways to look at this. And just to kind of make sure that I'm not missing anything here, the last one I forgot to go over was judgment. Judgment liens are typically valid for 10 years, but the exact period, it varies state by state. For example, like in California, a judgment lien can be renewed for an additional 10-year periods of time, but that's California. And the renewal of judgments in most states, creditors can renew their lien before it expires, which typically restarts the statute of limitations again. So you have to check. Not every company that owns a lien, a lot of times they sell these things off to debtors to try to collect on the debt. The debt gets dwindled down further and further and further. It's similar to a credit report. Now, there's so many loopholes in removing judgments and removing liens from properties. And I want to go over this in a step-by-step process, okay? And this is very basic. I'm going to probably have to do a second video where we deep dive on it. I want y'all to understand this. A judgment carries no power on a homestead. If your property that you live in right now and you're watching this is your primary residence and you get a judgment on you, you can remove the judgment from your property because that property is your primary residence. So, what is the way that you remove a judgment from a property? You make your property your primary residence, you get a homestead exemption to your taxes put in place, and then you just have to issue a written letter to the judger, the individual that is carrying the debt. They get literally 3 days to respond, and they have to respond via certified mail. In this instance, most of the time, and it's never not gone my way, they don't mail you back certified letter. And with that happens, you can then file a notion for what's called a homestead exemption of judgment. Homestead exemption of judgment. This is a document that you can record downtown where you are labeling your property as your homestead and the judgment cannot touch you. And you can remove it like that. Now, guys, I know that sounds crazy, and I want to just go ahead and show y'all a real life example here. Here, I'm gonna go to my Facebook because I've been doing this shit since like 2018, 2017, and I'm gonna show y'all one that I posted on here. Removing liens and judgments. Quentin. I should be able to find it. Post. This is crazy. It's funny that I can go back like this and see things. I'm sharing my screen. Check this out, y'all. This is a real deal that I did. Took me about 2 weeks to get this one done, but this lien has been affecting my seller's credit score as well as her ability to sell this house. Before meeting my partner and I, she said that she had tried to sell her house several times before wasn't unable to because of a stupid lien from 1995. This is what you call a release of lien. And just like that, $17,000 in debt goes bye-bye. And just like Hawaii's punk ass, we just removed things that aren't good for our sellers. I'm sorry. This happened when Kawhi Leonard had left the Spurs. I did not mean to put that. But this right here, guys, is a release of lien. This release of lien came because the debt was already had the debtor that was in place. This was a $17,000 loan that my seller had took out for the property. Now, this was when Security Federal Credit Union, Security Service Federal Credit Union, was originally part of RBFCU, which is Republic Federal Credit Union. Now, RBFCU got bought out by Security Service years ago. There's very few RBFCUs that still exist in San Antonio today. So this debt was from that creditor, and that debt, when that bank filed for bankruptcy, when the crash happened, they were part of the banks that were giving out falsy loans for people. It was called stated income. So in 2005 and in 2006, if Candace were to walk into my loan department and say she wanted to buy $1 million home, all she would have to do is say that she makes $1 million a year verbally. And I would just have to hear that. And then I could lend her $1 million to go buy $1 million property. That's why the market crashed. Now, there were a lot of banks that were giving out falsy loans like this. Now, me being a sleazeball loan officer, I would have given her that loan. Why? Is because I would make a huge commission on it. The bank would pay me a commission, which is typically a percentage of the loan. I think it's about like 1.2%. So 1.2% of a loan that I approved Candace, who never showed me proof of income, but told me that she made this amount of money, would give me like 100K commission from the bank. Okay. So like that's why the market crashed in 2007 to 2008 when that had happened. And so this lady had stated that she had this job, was making her $20,000 a year, and the bank gave her $17,000 loan, which they put that lien against her property. So that lien from that bank went out of business. My title company tried to go out there and figure out who the owner of this debt was. Turns out the bank got bought out by Wells Fargo, and then Wells Fargo sold this debt to Security Service Federal Credit Union. I walked into the office of Security Service Federal Credit Union with the lady who had gotten the loan, showed the debt to the people, told them that the bank went out of business, and it's telling us that we have to come here. The bank released the lien, signed the document with my seller, gave us that 17K off the sales price, and then that went away, and we were able to move forward with closing on this property. Insane, right? And so a lot of times we look at this debt and we're like, damn, there's a $17,000 lien against it. Most of you guys would have just backed the other way. Now, this is the reality. I didn't promise that that seller would make 17 grand more. That is not what we did. She wanted to make 15 to 20K over the debt that she owed against the house because she still had the mortgage and that 17K that was leaning there. Now, I added an additional $17,000 to my profit margin because of my assignment of contract. And so I want to show you guys something on why removing judgments and liens is so valuable. All right. Now, guys, again, if I'm offering a seller a specific amount of money for their property, that does not change just because I removed a 17K debt against that house. She would not have been able to sell this thing if I did not remove that 17 grand. Okay. And so how do you make more money by removing liens and judgments? I want to show y'all my assignment of contract. All of you guys have access to this, but this is the clause that I'm so proud of. Check this out. A signer may, at any time before closing, negotiate the underlying purchase in the contract with the original seller. A signer is entitled to the entire difference between the contract purchase price and this assignment. This word right here, this difference, if any, will be paid as an additional assignment fee. This verbiage allows me to take that $17,000 debt removal that I did and add it to the bottom line. So my 10K assignment fee on that deal jumped to a 27K assignment fee because of this. The seller still got what they wanted. I got the property cheaper because we removed that debt and I increased my assignment fee. And so, yeah, she never thought that she would ever sell this house, ever, until she met me and I was able to get it removed. Now, I wanted to show you guys a real example and go over that case study because a lot of you guys are sleeping on this specific skill set. It takes time and research. We had to figure out who the bank belonged to first, who the debt belonged to, because I saw a 17K loan for a bank that don't even exist anymore. And it got sold out to RBFCU, sold out to Wells Fargo, sold out to Security Service Federal Credit Union. We walked in the building. They gave us the removal of lien like this. My seller was 70 years old. She didn't care. She just wanted to get out of the home and get into a nursing property. That's what she was trying to do. And so, guys, I really wanted to go over that case study with y'all and how I combine removing a lien and removing a judgment to increasing my profit margins on an assignment of contract. So, again, does that always work? Not all the time. The steps to this are, if you have a lien and it seems to be the only debilitating thing, And for whatever reason, this lien is something that is old and outdated. You can tell it does not need to be on the title search. These are the steps. Step one, you gather all necessary documentation, including lien details and any supporting evidence that states when the debt was created. You can do this by working with your seller. They should have access to all this documentation. If they have no paperwork, then you got to get on the computer. You got to start doing some research. You can look up, you can get a copy of that lien from your title company, and the title company, they'll have a loan doc number. And you can go to every single bank online, all the big ones, Bank of America. You can go to, Wells Fargo. You can go to Chase Bank, and you can type in that loan number. And if nothing pops up, then that means that you have a lien that can be removed. Otherwise, someone owns that debt. Communicating directly with your lien holder to negotiate the payoff or settlement. Now, a lot of times, guys, what I'll do just to get a deal off of the table, get it done, I'll tell my debt collector, right? So, like, you guys know I like going after tax delinquent properties, right? So there's tax loan offices. I don't know if y'all know what those are, but essentially, if you're delinquent on paying your property taxes, you can go to a place like an establishment, and essentially what they'll do is they'll lend you the money to pay your taxes. And guess what? If you don't pay them back, what they'll do, they'll put a lien against your property, and then after about a year and a half, they'll try to foreclose on you for not paying your property taxes on a loan that you got to pay your property taxes. Some people will get a loan to pay their taxes, dude, and then never see that company again. And then the company forecloses on that house. They get that property for 10, 15, $20,000. And so why is this important? They're not debt collectors. They're just going to wait until the time frame goes. Now, are these businesses, tax loan offices, in the businesses of flipping real estate, renovating houses, dilapidated properties, and reselling them? So if they foreclose on it, well, okay, they're never going to get their money back, but now they have a property that is dilapidated that they can't sell because they don't know how to do what we do as real estate investors. Their business is just collecting debt. That's it. They loan people money to pay their taxes, and then they get the money back eventually or over a period of time. And so contact every tax loan officer that you can. You can Google this, Google tax loan officer near me. Go to those offices and ask them for a list of properties of people who haven't paid their debt back. Tell them this: if I find this person and I get your money, will you settle that debt for less so that I can make a profit? Now you're becoming the debt collector. And they're going to ask you, well, how? You tell them, well, I'm a real estate investor. I buy properties like this all the time. I'll put one of these properties under contract with the option to purchase it. I'll send it off to the title company. I'll get your information so the title company can contact you. And I would like to have at least 70% shaved off the top so that I can make a little bit more money for getting you your money back on this property that you don't have the time to go and chase after these people. There you go. Like there's a lead source that is slept on that most people don't fully recognize. All right. And so again, lien holders, just because they hold the lien doesn't mean you have to pay them in full. You can settle the debt for less. If not, you can zero it out completely. So like anytime that I'm dealing with a lien that I found the debtor, the individual doesn't want to budge, he doesn't want to release it for free, then let's negotiate his ass down. Because you wouldn't have been able to get this property, and nor would you have been able to get the money back for it if I didn't intervene and convince this person to sell to settle these debts. And so now we're offering for a reduced payment to satisfy the lien. There's so many benefits of this. It's a quick solution for the lien holder. And literally, like, you can request in a written agreement for the settlement terms. All right. So let's say this: I'll settle this lien, but you want 30%. I'll give you 30% up front, 20% when we close. All right. So now you're getting 50% off of a $20,000 loan. You're paying 10 grand at closing versus 20. Your seller can make an additional 5. You can make additional 5. And that's how that works. Now, once you have the agreement in place, now it's your time to obtain a release of lien. So remember, step 1, step 2, step 3. Contact the lien holder. Step 2, obtain the release of lien. Step 3, negotiate the settlement. Step 3, obtain the release of lien. At this point, you should have exactly that piece of paper, that document that I showed you guys in the video, right? In the when I shared my screen, that is a satisfaction of judgment or a release of lien. Once you have a copy of this, you send it off to the title company. That's it. Now, again, sometimes you might have delinquent taxes against a property. Those ones, unfortunately, are non-negotiable and unavoidable. You will have to pay those delinquent taxes and fees directly to the county treasurer, tax assessor collector. They call it a lot of things in the business, so it might be different where you're at. You might put in tax treasurer, and that's what pops up. Tax assessor, that's what pops up. Tax appraiser, that's what pops up. These are places where people go to pay their property taxes. Property taxes are the only thing in America that is unavoidable. You have to pay them. You can put them on payment plans, but you have to pay them. All right. Eventually, what you do here is you go and you request these payoffs, you pay them in full. Your title company will probably request payoffs for everything. And then you get confirmation of when the lien is removed from public records. Now, normally, guys, it's not taken off of public records. There will be a release of lien that was filed that removes the lien or judgment from the house. All right. And so, again, this is your checklist for your DIY resolution for all of this. Verify details and debt amounts, right? Contact the lien holder with an initial offer, request a written release agreement, and then follow up to ensure that the public records have been updated and you were able to get this thing done. Now, guys, this is the DIY resolution for this. I wouldn't recommend that any of y'all just go out and start removing liens without legal advice. Okay. So, just for the sake of this video, I'm not an attorney. I'm not giving you legal advice. I'm telling you guys things that I've done from experience, which don't require me to have a license to preach because I'm teaching from experience. An attorney can assist you with all of these things, but not just any attorney. If I'm going to work with an attorney, that attorney has to be a real estate investor. I just can't do it if they're not. If they're not a real estate investor, it's somebody that I really can't see myself working with, y'all. And they have to understand what it is that I am trying to do. But an attorney can do everything for you. The attorney can literally negotiate lien removals. They can dispute against judgments in the court of law, so we could take it back to court and see if we can get it removed. We can again choose an attorney that has real estate experience and title issue experience and provide them with all of the relevant documentation that we found. And so the attorney on your behalf can negotiate with your lien holders. And sometimes it might work better this way. Not only that, you don't have to go down there and pay those filing fees. Your court, like your attorney can file motions to remove invalid or improper filed liens from the county themselves. And so again, like this is one of the best things about it. And on top of that, the attorney can ensure compliance, that there is compliantness happening. Okay. And so checklist for the attorney way. I went into detail on how you can do it on yourself because that's how I do it. I don't have an attorney. I did at one point, but I do it myself now because I know how to do it. But for an attorney, select an experienced attorney. 2, provide them all the proper lien documentation on what it is that you're trying to do. And then 3, you can have them negotiate and litigate all those different strategies in the court of law to remove those things. And then 4, they can confirm that the notions to remove these liens have been filed within the county records and everything's up to date. And so again, guys, whenever you're utilizing these strategies, it does require legal help. Unfortunately, the advice that I'm giving you is only based on my own personal experience, not something that might be valid where you are at. You have to make sure that you consult with an attorney, and it's free 99. If anything, it'll cost you $500, $300 to be able to go in and really get advice from a real estate attorney on what they can do to help you in your state. Because again, like I mentioned at the beginning, lien laws and judgment laws vary from state to state. What I've been telling you guys today works very well in Texas, and it should work where you're at as well. But just to double verify the advice that you're receiving from me, again, these properties that you're finding, make sure that you consult with a real estate investor experienced attorney that is very savvy in title law and in title regulations. All right. And so I'm going to answer some questions. I'm going to go ahead and land the plane on the recording, and then I'm going to stop recording for all of you guys. And again, this will be a recording that I will upload so that you guys can go through it as well. As we begin to progress through the cheat code, you're going to be learning a lot of stuff like this. And there might be some stuff that might be hieroglyphics. Just stay here and you'll learn it week by week as we begin doing it. You guys will start finding real estate deals that have these types of situations. And then we'll start doing case studies where I partner with you on your properties and I help you guys remove these liens and judgments. All right. So I'm going to land the plane on the recording. This was removing liens and judgments from properties, as well as a case study session. Appreciate all you guys for watching this recording. Remember, upgrade to annual and it unlocks all the advanced level cheat code stuff. I'll see you guys on the next one.